What's up, everybody? We have finally got to the moment that we get to hear from Miss Becky Hill, the clerk of court from the Alec Murdaugh trial. Hear what she has to say. Is she going to deny everything? Is she going to admit that she spoke to some of these jurors, but say it was just everyday talk about snacks and where they were going to go? Is she going to incriminate herself? Is she going to plead the fifth? What is she going to say? How much is she going to say? We get to find out today. We have an affidavit signed by Becky Hill under oath attached to the Attorney General's motion to strike Alec Murdaugh's motion for new trial, basically arguing it is not credible. Those jurors are not credible. Half of them did not even deliberate and come to the guilty verdict. Therefore, there's just not enough here. And if there is enough here, Judge, it should be a very abbreviated evidentiary hearing where you ask the jurors a few questions and you will find out none of this is credible. It's just more from Alec Murdaugh and his legal team trying to muddy the waters and create problems where none exist. So hit that like button if you guys haven't already as this saga continues. Subscribe to the page if you want more on all of the cases that we are following so you don't miss whatever the latest update may be. So we're going to take a look and kind of summarize this motion and not read all 50 pages. I won't bore you with that, but here's their response and their motion to strike. So first, they want the court to summarily just deny Alec Murdaugh's motion without an evidentiary hearing. But they say if the court does hold an evidentiary hearing, they want it to mirror this Green case. And they want to bring the jurors in and ask them these questions. Was your verdict guilty on both charges, and is that still your verdict? Assuming they answer yes. Was your verdict based 100% on the testimony, evidence, and law presented at this trial? They will probably say yes. Number 3, was your verdict influenced in any manner by any communications with any of the bailiffs or any other person outside of the 12-member jury? I think the case that they referenced was an issue with bailiffs talking to the jury, not the clerk, but assuming they say yes to that. And then number 4, did you have any communication with any of the bailiffs or with a third party not part of the jury? And if so, please relay to the court what those communications were. So this is the only area where it could kind of expand into a yes or no and then explain. But Murdaugh's team is going to argue these questions are improper because the burden is not that they have to show it would change their verdict. And these questions very specifically go to whether or not the communications affected their verdict. Because those first couple questions are irrelevant if you listen to the way Murdaugh's team argues it. And the court's going to have to determine what is the burden here. Is it any communication means we have to have a hearing and potentially a new trial? Or is it communication that rises to the level of changing the minds of the jurors? In my opinion, I know this is going to be an unpopular opinion. If the clerk or bailiffs or any third party were having communications about the trial, whether positive or negative, regardless, if they were having those communications in direct violation and opposition of a court order and a court instruction multiple times a day, which they reference in this motion, then there needs to be a new trial, regardless of if a juror thinks or testifies to the fact that it affected their verdict or not. That's one man's reading of the case law. Doesn't mean that's how the court is going to come down. But these are the questions they want to ask. And they don't, looking at this page, want counsel to interrogate these jurors. They said that the established practice is that when considering allegations of inappropriate communications, the court should voir dire the complaining juror, each juror who engaged in the final deliberations, which would cut out a couple of Murdaugh's jurors, right? Because they didn't end up on the actual jury. I'm calling them Murdaugh's jurors, but the ones that are favorable to him. And the alleged improper communicator with a mind to at least, and that would be Becky Hill, taking the stand and getting interrogated. They don't want that. But if they do allow it, the questions are whether the communication actually occurred, and if so, its context and substance. 2, the number of jurors exposed to the improper communication. 3, the weight of the evidence properly before the jury, meaning what has come before the jury that's actual evidence in court during the trial, not what somebody else told them. And 4, the likelihood that curative measures were effective in reducing the prejudice, meaning the lawyers in their argument saying, don't listen to anything else, just make your decision about what's in court. The judge saying you shouldn't talk to anybody else because none of that should come into play, just what you hear here. And if they were told this enough times, did that cure the problem? You'll notice with these questions, it doesn't necessarily say it has to flip their verdict. So there is some gray area, at least. I mean, I think it's clear this communication should not happen. It it casts a horrible shadow over our judicial system if this stuff is allowed. And then they're able to say, oh no, he was for sure guilty because they just agree with the clerk's statements or they trust the clerk or whatever it may be. We just can't have this stuff happen. Now, if they say she never had these conversations and all she talked about was the weather and food, then fine. That's fine. But if she did, in fact, comment on his mannerisms, on what the defense is going to argue, not to trust Alec Murdaugh, that's problematic. The court should not permit interrogation of the jurors by the parties or their attorneys. I hate, because I agree, jurors are citizens who have committed tremendous service to their community and country through their sacrifice of time and effort to weigh on the most serious issue that can be put to them. But I disagree. I think they should be interrogated. Interrogation is a scary word, but they should be questioned nicely, not combatively. Simple questions they can answer to see what happened. Throughout this, they argue again, the judge instructed the jury over and over again not to talk to anybody, not to listen to anybody, and they didn't come forth then. So why are they coming up now? Number 2, they also stated that all of these statements these jurors are making in favor of Murdaugh sound eerily similar to things the prosecutor said in opening statement and closing arguments. So maybe they're misremembering because Creighton Waters said, watch his body language. He cries in closing statements, all those sorts of things. They're going to try to trick you, whatever. So that makes sense. And really the statements came from Creighton Waters, not from the clerk. When you get down to page 50, these are all the sites of the times the judge said, don't listen to anybody on the outside. Don't talk to anybody. Page 15 gets into what Harpootlian said. We're talking about the egg juror now. And they basically say all this was cured because the judge said he struck the egg juror for nothing that had to do with Facebook or Miss Becky. So that's a moot point. Additionally, when Harpootlian had the chance to argue it, he said, quote, I'm not going to argue any more about this. I'm going to defer. It's your call, your judgment. Your Honor, I'm not going to argue with whatever you do. Okay. And of course, the AG is going to take that quote and say, Judge, now he's arguing about it. He already waived this argument. He can't argue this. But that's not actually how it works for appellate purposes. You can still make these arguments, especially if things come up that he didn't know about, that the Facebook post was actually fake, and that potentially Miss Becky made it up is what they're alleging. Okay, I'm not saying that's true, but they're alleging that Miss Becky made this whole thing up to get a juror struck because she thought the juror might vote not guilty. So that absolutely is new information he did not know at the time when he said, I'm not going to argue with you anymore. But the AG's office, it's a good use of a quote, somebody else's words against them. So just to give you an idea of what the state is looking to do here, the state moves to strike all such material as regards Murdaugh's claims regarding the Facebook post, book deal, and post-trial media interactions as, here's the reason they want to strike it, it's immaterial, impertinent, and scandalous. Interesting legal terms to strike something. Not something most judges are going to say, okay, I'm going to strike it because it's scandalous. Immaterial, I guess, would be irrelevant, potentially could have some legal binding, but basically that's the type of language they use throughout. And just a quick summary here of one paragraph of what they're looking to do. Wherefore, the state respectfully requests that this court summarily deny Murdaugh's motion for new trial, or, barring that, convene an evidentiary hearing consistent with that conducted in the State versus Green, which we read those questions already. Upon hearing the testimony of the jurors and witnesses presented, find Murdaugh's allegations to be not credible and deny his motion for new trial. So, what we're going to take most of our time doing today is reading Miss Becky's affidavit and the statements made by all of these jurors. I think they have 12 juror statements. Some of it is hard to read. So what I'm going to do first is read kind of the AG's summary, which Clerk Hill denies commenting to the jury regarding Murdaugh's defense or testimony. Okay? It's a couple pages, so we're going to read it, but generally that's what she does. She denies everything. Here are what the jurors say. The three boxes are: did they hear remarks on evidence by Clerk Hill? Remarks on evidence. See one-on-one chats by Clerk Hill with jurors. And do they have any other concerns? Number one, no. Maybe generally pay attention. That's all that Hill said. Didn't see any one-on-one talks, and if he had a concern or he or she had a concern, it was that people were overly cautious. Number two, hear remarks on evidence by Clerk Hill. Watch Murdaugh's body language. Honestly, that would be enough for me. This is one of the jurors that deliberated. If she said, watch his body language, that's enough for me. I know people are going to disagree with it and hate me for it, but I really think that's enough. You cannot be doing that as the clerk of court, and you should know that. And frankly, it's in direct opposition of what she says. She denies commenting to the jury regarding Murdaugh's defense or testimony. His body language during his testimony, to me, is in opposition of that. I'm adding his testimony. Maybe she just meant sitting at counsel table, which is still inappropriate. See one-on-one chats? No. Other concerns? No. Remarks from Hill? No. Graphic material warning? Totally fair and appropriate. See one-on-one chats? Yes. Saw chat regarding financial child support. I don't know what that means, but again, one juror says she said something about body language. Now another juror saying she saw one-on-one chats. No other concerns. Juror 530? No, no, no. Juror 544? No. Generally pay attention. Look at body language and be observant. It is not appropriate for a clerk to tell jurors to look at body language. That is not appropriate. So that's two jurors that say that. No, and then other concerns. Juror 630 is a tenant of Juror 785 who is upset, warned by Counsel Harpootlian of a subpoena if they did not talk. And they're going to say these threats that if they don't talk, they're going to get a subpoena. But in reality, I think that that's nothing more than trying to get information. Now, I think it's going to be easy for these jurors to be negative about Harpootlian and Murdaugh's team. And if Judge Newman is the judge, it's probably going to be a shared feeling. But, you know, as a lawyer, again, different between lawyers and lay people and jurors, a subpoena is somewhat of a threat, but we're not asking you to lie if we subpoena you. We're asking you to come tell the truth under oath. That's really what a subpoena is. Juror number 572, no, no, no. 578, declined to discuss the case or deliberations. Isn't that interesting? Juror 589, no, no. Spouse warned by Harpootlian of subpoena. No interview at the time of this writing for another juror. No, generally pay attention. Heard no body language comments. So two jurors did from this group. One didn't. Yes, had chat regarding financial/child support. Saw clerk chat with others. So juror 729 now is the second juror to say that they saw the clerk have one-on-one chats. Denied statements regarding them in affidavit of juror 785. Uncomfortable when Harpootlian waved gun around. I can't blame him for that. Juror 826. No, no, no. Juror 864. No, no. And it was Creighton Waters in court argument who told the jury to watch the body language. Well, not according to these two jurors up here, 254 and 544, or a couple of Murdaugh's jurors. They also have some statements from court staff who generally agree with Ms. Hill. So now let's get to the actual under oath statements. Signed affidavit by Mary Rebecca, or as we know her, Miss Becky Hill. Over the age of 18, legal mental capacity to give this sworn affidavit, submitted at the request of the AG's office. to address specific allegations contained in affidavits attached as exhibits to Mr. Murdaugh's motion for new trial, filed October 27th. There are numerous misrepresentations and false statements contained within the motion for new trial to which I was not requested to specifically address. As such, this affidavit is not intended to address every allegation within the motion for new trial. So what is she doing there? She's leaving it open. She may argue further in the future. Anything that she doesn't deny here does not mean that she admits it. After being elected in 2020, she served as the clerk of court in Colleton County. She was elected during the state of South Carolina she was the elected clerk during the Murdaugh trial. She reviewed Murdaugh's motion for new trial. And as to the allegations contained within the affidavit of juror number 630, I did not tell the jury not to be fooled by evidence presented by Ms. Murdaugh's attorneys. I did not instruct the jury to watch him closely. I did not instruct the jury to look at his actions. I did not instruct the jury to look at his movements. I did not say to the jury this shouldn't take long. She didn't say, watch him closely, look at his actions, look at his movements. Yet, two of the jurors did say. She said, watch Murdaugh's body language. Generally, pay attention, look at body language, and be observant. Those do not say the same thing. So who's telling the truth? The jurors or Miss Becky? I don't think both can be telling the truth at this point with these explanations. When Juror 826 asked to speak with me, the conversations took place in the jury room hall within earshot of Bailiff Bill Polk. The conversations did not involve evidence, witnesses, or substance of the trial. As to the allegations within the affidavit of Holly Miller discussing an alleged conversation with juror number 741, I did not have private conversations with juror 826 in a bathroom. Let's see, what did 826 say? Juror 826 just said no to everything. Okay. So she says, I didn't have conversations in the bathroom. My conversations with 826 did not involve the evidence, witnesses, or substance of the trial. So is she admitting that she did have one-on-one conversations? Just not in the bathroom, and it didn't involve evidence, witness, and substance of the trial? This is why we need interrogation, questioning. This is why we need questioning. We need to get to the truth and get to the bottom of what actually happened. Because these vague terms, leaving certain words out, because words are important, it doesn't actually give us our answer. It just basically denies as stated, which when people do that, when lawyers do that in cases, it means if you state it a different way, I may admit it. During the trial, I did not tell members of the jury that the media would want to interview them at the end of the trial. I did not hand out business cards of media personnel. I did not tell jurors, y'all are going to hear things that will throw you off. Don't let this distract or mislead you. As to the allegations of 785, I did not tell the jurors to not be fooled by evidence presented by Alec Murdaugh's attorneys. I did not ask juror 785 whether juror 785 was inclined to vote guilty or not guilty. I did not tell juror 785 that SLED and Colleton County Sheriff's Office personnel went to her ex-husband's house. I did not tell juror 785 that I would reinstate a restraining order against her ex-husband. I did not state to juror 785 that Murdaugh's probably got to him. I did not ask juror 785 her opinions regarding Mr. Murdaugh's guilt. I did not ask 785, well, what makes you think he's guilty? I did not discuss the evidence presented at trial with 785. I did not tell 785 that everything Murdaugh said has been lies. I did not tell juror 785 to forget about the guns. They will never be seen again. I did not tell 785 about the views of the rest of the jury. I didn't tell 785 that if the foreperson would just go in and ask for a raise in hands, this would all be done with, over and done with. I did not inform 785 that everyone needs to be on the same page. I did not fabricate, nor did I create any Facebook posts related to 785. And as to the allegations within the affidavit of Holly Miller discussing an alleged conversation with juror 326, I did not tell the jurors they were prohibited from taking a smoke break during deliberations. So, she says a lot and nothing all at the same time. She denied the specific quotes she decided to pull and put into this affidavit. I don't know if she had help with the AG's office or with her own lawyer, but she doesn't really state a lot. She instead just denies. What's interesting too about like the smoke break stuff is Eric Bland, who's representing some of these jurors, came out and said, oh, well, smoke breaks are not an absolute right. So, sometimes that just happens. That doesn't mean we need a new trial. Well, did she say no smoke breaks or did she not? People have talked a lot publicly. People involved, attorneys involved, jurors involved, clerk of courts involved, judges, jurors. So many people have spoken publicly about this case that if their stories are not consistent, there's going to be problems because it is on the record. It is here and alive forever now. Let's look at some written statements of the jurors, the ones that we can read. Juror 193. So we got the summary. Let's see if there's anything else in here. No, I was not coerced to give my verdict. I came to the decision on my own free will. So what's interesting, actually, that just reminded me, in their own little chart, what they did not put as a column is, did any of this affect your verdict? Or, like the question referenced above from the Green case, was your verdict 100% based on the evidence presented at trial and no outside influence? Because I think they all would have checked yes to that. I think that would have been good argument for the AG's office if they're arguing that's the standard, but they almost are admitting it's irrelevant with this chart. However, it is in the juror statements, as we read here. No, I did not feel anything was said to influence my decision-making. I did not witness any private conversations pertaining to the trial. Again, I don't know if they had any help, but they don't say I didn't witness any private conversation. They say I didn't witness any private conversation pertaining to the trial and was not approached by anyone. I did not witness any jurors speak privately about the trial to each other. I did not feel, and again, about the trial. So if they're speaking privately with anybody and you can't hear what they're talking about, how do you know if they're talking about the trial or not? I'm not calling anybody a liar. I'm just saying, like, let's dig into what these qualifications within these sentences mean. What did you see? Did you ever see two people talking where you couldn't hear what they were saying? And if the answer to that is yes, that's all you can answer because you don't know what their conversation was about. Because by definition, if you can't hear it, then you don't know what they were talking about. I did not feel pressured to come to a quick verdict or that I was required to reach a verdict in a certain time frame. I have not spoken to the defense team. To my knowledge, no juror attempted to begin deliberations early. Okay. Juror 254. This was my first time as a juror, and I found this experience was very rewarding as a civic duty. During the time, we as a jury were treated with respect and received anything that we requested. The only time that I had interaction with anyone was through the bailiff, other than one time when we as a jury was waiting to go into the courtroom and a comment was made to watch his body language. She doesn't even say, or this juror doesn't even say who said it. But she said she only talked to the bailiff other than this one time. And she's definitely not referencing Creighton Waters, I hope, because I don't think he would talk to the jury when they're outside the courtroom. So I'm going to assume she means Becky said, watch his body language before they enter the courtroom. Even Murdaugh's greatest haters, and I am not a fan, that dude deserves to be in prison for the rest of his life for everything he's pled to and what he's been convicted of here. But if it wasn't a fair trial, let's do it again. And if he gets convicted, he'll serve multiple life sentences as he deserves. If he doesn't get convicted, he'll still serve life in prison. But this stuff cannot happen. I would be so pissed if this happened in my case. And even more so if I was the defendant. And the clerk's going around telling the jury, hey, watch his body language. What do they think that means? At that time, I didn't take it any way other than to watch his body language. That comment didn't persuade me of the decision that I ultimately made during deliberations. I would be shocked if appellate court judges, if the trial court, whether it's Judge Newman or somebody else, doesn't give a new trial. I'd be shocked if appellate court judges don't see or take issue with this. Juror 326. I believe that my interaction with Miss Hill, the court clerk, was limited to information from the judge or about important events such as graphic material or how long of a break we would get. I do not believe she acted outside her role as court clerk and acted in a very professional manner. Juror 530. I did not at any point feel pressured to make a decision throughout the trial, nor did anyone attempt to sway my decision by any means of communication. At no point in time throughout the trial did anyone attempt to have a one-on-one conversation with me for any purpose regarding the trial. To the best of my knowledge, there was no court official or employee that questioned myself or other jurors regarding the trial or its outcome. To this date, I have not been contacted by the defense regarding the new allegations or any topics throughout the trial. I did not observe anything that I perceived to be unethical by any court employee. Okay, Juror 544. While on the jury, Ms. Hill never made me feel as though she was trying to sway me either way, innocent or guilty. Ms. Hill spoke to us as a group in regards to what types of things we would like for snacks, breakfast, and lunch. Ms. Hill mentioned if we were sequestered that we would be staying at a hotel and we would be given time to gather our things to stay at the hotel. She also stated that an agent or officer would be with us the entire time. I felt she stated this to us as trying to keep us informed of what may or could happen. I was never made to feel pressured to say or do anything by anyone, court employees or co-jurors. I never witnessed any jurors going into a room alone with Ms. Hill. This is 572. No, I was not coerced to give any answers. My decision was of my own. No court employee influenced my decision. I did not have any private conversation other than myself talking to Miss Becky about me not using the stairs because of my knee injury. I did not witness any private conversations amongst the other jurors. I did not hear or witness anyone or any court official stating to us, the jurors, that we should not listen to the witnesses or shouldn't take long, etc. No one made me feel that I had to arrive to a quick verdict, and I didn't. I or the jurors would not be able to leave. No one from the defense team ever reached out to me pertaining to the Murdaugh trial. Something the juror that was ejected from the trial stated one morning on the van that her husband told her we were going to Moselle and we told her no discussions. Okay. I don't know if that's the egg juror or somebody else. Oh boy. I was a member of the jury when we would go something to the jury room. People did go to the rooms where they wanted to go, and most of them stayed in the same room from the beginning. Ms. Hill would come in periodically to see if we needed anything and something us. Question: did Ms. Hill ask questions about your opinion? No, she did not. Did Ms. Hill pressure you to speak to something? I felt no pressure to speak to anybody. During a 6-week trial, I found that with 2 different rooms, there would be a lot of gossip between strangers. Each room was filled with men and women. The room I was in was a quiet room, while the other room was louder and filled with the conversations of work and private life. I spoke with Becky Hill on a couple of occasions about my financial burden and that I needed to speak with the judge. Smoke breaks once a day, sometimes more. She did come speak to others, but I didn't hear the conversations. And there's a lot of it's absolutely necessary to have an evidentiary hearing and question these jurors. There's way too much unanswered, way too much gray area. The trial, I had a very uncomfortable feeling as the defense attorney would wave the gun around as if he never held one before. During our smoke breaks, we would talk about lunch or what we are missing at work. There was always something to talk about or someone to talk to. After 6 weeks, it came time for deliberation. Everyone took an anonymous vote, followed by open discussions and questions. It was fast and smooth, but I felt no pressure. I was set in my decision after everyone discussed their thoughts. We voted again. Every vote came back guilty. We checked multiple times to see if all were comfortable with the decision. If we needed to wait, we would have. On the day of sentencing, we were approached by Dateline, I think, and Miss Hill, who asked if we wanted to do an interview. We told her. She seemed disappointed. Oh, we told her no. She seemed disappointed, but let it go. So again, a little more context there. They met with Dateline. Do you want to do an interview? Miss Hill asked if they want to do an interview and was disappointed when they said no. I'm sorry, but there's enough here to shade impropriety, at least the appearance of it. Even these honest jurors, I feel like these jurors are being honest. Juror 729, did you ever hear anyone tell the jury not to be misled or fooled by Murdaugh defense? I did not hear anyone say that. Did Miss Hill ever ask you your opinion about the trial? No, I did not have conversations with Miss Hill like that. Question, did you ever feel pressured to make decisions prior to deliberation? At no point during the trial did I feel pressure to make my decision. Thank God that we're done with that, those pages. All right. This is juror number 826. Did you feel pressured at any point during the trial to make a decision? No. Did any court official or court employee persuade you or any other juror one way or another as it pertains to guilt or innocence? How would she know if they persuaded, or how would this person know if they persuaded any other juror? Answer, no. Did any court official or court employee have a one-on-one conversation with you or any of the other jurors that you saw, is what it should say? No. Did anyone attempt to contact you after the trial regarding the trial? No, except for the media. Did you see anything during the trial that you perceived to be inappropriate or unethical? No, not that I recall. Juror 826, did any court official or court employee question you or any juror prior to the deliberation about decisions of the jurors regarding guilt or innocence of the defendant? No, not that I'm aware of. Juror 864, no one pressured me to make my decision of guilty. No one influenced me to make any decision. Something guilty verdict. I can't read this one. Too sloppy, sorry. All right, and then witness statements of court staff. I do not have any personal knowledge of any contact between Rebecca Hill and the jury deliberations during the Murdaugh trial. My job as deputy clerk was mainly to gather lunch orders and deliver lunch to the jury and others. I personally had no contact with any of the jurors other than delivering their lunch and making sure they had what they ordered. I spent the majority of time in my office in family court and had no contact with the trial or any matters pertaining to the trial. I did not observe Ms. Hill or any other court employee speak with any jurors during the course of the Murdaugh trial, except the bailiff that was assigned to them. I was asked to look through social media for a past post regarding a juror speaking. None was found. An apology post that may or may not have been associated with that was located and given to Ms. Hill. These people have to be scared at this point. Let's be honest. If you're just like a court employee, you're like, I don't know what's going on. I was asked to look for a post. I found something that looked like it could have been an apology, but I'm not sure. During the Murdaugh trial, I served as the jury coordinator. My responsibilities consisted mainly as being the primary interface between the jurors and court officials, like any medical or personal issues, etc. In my jury coordinator position, I did not personally hear anyone interfere. Gosh, I can't even read what that reads. Influence? I don't even know what that says. Have influence over any of the jurors. I did not hear the clerk of court, Rebecca Hill, trying to influence the jurors. My jury responsibilities kept me busy, and I didn't hear anyone trying to influence them. This trial was very important for Alex Murdaugh and the Colleton County Courthouse, so I tried to keep everything professional and problem-free. Yeah, Becky Hill should have done that. Together for 6 weeks, I have not seen or talked to any of the jurors since the trial. Continued. Did you hear anybody that could have misled? I don't have any knowledge of this. I didn't hear anyone ask the jury any questions. I did not, except for 2 issues. One was a personal female issue, and one was a child support issue with a male juror. I was present with her for both of these issues. These occasions were at the very beginning of the trial. My job in the Murdaugh trial was to control the gallery and seating them and lawyers and prosecution in proper place during the trial. I, in no circumstance, saw anything inappropriate by Becky Hill. All I witnessed was the clerk of court performing their normal duties as clerk. One other thing that was interesting in the motion I wanted to point out before we stopped. Where is it today? When it talked about the jurors, here we go. In addition to the jurors, perhaps most importantly, none of the jurors who willingly interviewed with SLED reported feeling any pressure or influence to reach their verdict. In addition, SLED interviewed court staff. I can't wait to hear what Alec Murdaugh's lawyers think about SLED being involved in handling these interviews. So to me, Becky Hill denies all the allegations. No surprises there. A lot of jurors provide good information for the AG, but a couple of jurors absolutely, in my opinion, ratify that comments were made about body language, which is important. And while he's on the stand talking about his testimony is evidence in the case, could persuade jurors, is not what the clerk of court is supposed to say. Some of them saw one-on-one conversations, didn't know what they were about. Inappropriate actions occurred, in my opinion. I absolutely think they should have a evidentiary hearing, and I think the judge should get to the bottom of this. Now, maybe there is some misunderstanding. Maybe it's no big deal. Maybe there won't be a new trial. But at this point, I think there must be an evidentiary hearing. Let me know what you think in the comments. How bad do you think this is? Do you think it's a nothing burger? Do you think Murdaugh's team is just exploding this and making a big deal about it for no reason? Let me know what you think. Whether you agree or disagree with my take, I appreciate you joining me and watching these videos. Hit that like button on the way out, and don't forget to subscribe to our channel if you haven't already. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us, lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You